Lord.
Registrar, when are we sitting after the gubernatorial election?
My Lord, our sitting is starting on the 14th, 15th, 16th of this month, my Lord.
Which day is 16th? Is it a Thursday?
Yes, my Lord, it's a Thursday.
Okay, Mr. Ojo, you come back on Thursday for the ruling. 16th of March, please.
Okay, my Lord, as the court pleases.
This case is hereby adjourned to 16th of March 2023 for ruling. Hearing notice to be issued and served on the claimant and the other defendants.
As the court pleases.
Call the next case.
Suit number NICN CA 08-2019 between Mr. Oko Anthony Ajuka and Saturn Mining Company Limited. My Lord, the parties are absent.
Appearance. Appearance.
With utmost humility, my Lord, my name is Eno Edet.
Yes. Edet.
My humble appearance is for the defendant.
Any appearance for the claimant?
My Lord, Mr. Kakipema usually appears for the claimant.
Okay.
He's online, my Lord. I don't know whether he's online, my Lord. Maybe muted himself.
Okay.
I don't know what went. He was online.
What is I can't see his face. I cannot see any in CCAC.
He was online. Exchange greetings when we were online.
I'm seeing one camera, but there is no the person who has that has not okay, it's not that. Yes. Any appearance for the claimant?
Sorry, my Lord. My Lord,
yes.
My Lord, may I know which number I was offline? I don't know. Technically, I just got off. I've just rejoined. Let me be sure it's not my case I just called.
Is your case?
Registrar, call it
Is your
again.
case, counsel?
Okay. Well, especially my Lord, Nsika Kipeme appears for the claimant.
Yes. Yes, this matter is for adoption.
Yes, my Lord. And my Lord, we have
filed your addresses?
Yes, my Lord, the claimant had filed his own address.
You have filed your address?
Yes, my Lord. We filed as far back as 10th of January.
And Edith, have you filed your address?
No, my Lord, we haven't.
You are forfeiting your right to file address because
No,
the matter
Lord,
is for adoption. You did
My
what?
Lord, we filed before the court. There's a motion before my Lord, my Lord.
Motion for what?
My Lord, it's a motion to set aside the order my Lord made on the 13th of December 2022.
What was the order for?
The order was for closing the
Which order do you want to set aside?
My Lord's order for closing
Have you served the application?
Yes, my Lord.
Have you served the application on the claimant?
Yes, my Lord, we did serve it.
Mr. Inskak.
Yes, my Lord.
Have you been served?
My Lord, the motion was filed yesterday and served on us yesterday. My Lord, we have a
Are you
comment
ready?
to make.
Are you ready for it?
My Lord, we have a comment to make on this motion.
Okay, I will give you date. Registrar, give me date.
Okay. 22nd March, my Lord.
Sorry?
March 22nd.
This case is hereby adjourned to 22nd day of March 2023 for hearing of motion on notice filed by the defendant for setting aside order of the court.
As the court pleases.
Court pleases.
Call the next case.
We thank my Lord. May we
Suit
proceed.
number NICN CA03-2020 between 1. Roslyn Achibong Enameti, 2. Mary Eyo Ewa, 3. Stella Adon Shie Iki, and 1. The Governor of Cross River State, 2. Government of Cross River State, 3. The Attorney General and Commissioner for Justice, Cross River State, 4. Cross River State Civil Service Commission, 5. Cross River State Judicial Service Commission. My Lord, the parties are all absent.
Appearance.
With profound respect, my Lord.
Yes.
Lucian Arium.
Yes.
Lucian Arium, ADCL.
Yes.
My Lord, my appearance is for the defendants.
Any appearance for the claimants? Yes, Lucian, what is the position? This matter is for report of settlement.
Yes, my Lord. My Lord,
Yes,
we
what?
crave your indulgence because the Attorney General has not been able to sign the settlement, the terms of settlement, my Lord. My Lord, we crave your indulgence for a date. You ask personally to be given some time. Hello?
Yes, I'm with
Hello?
you.
Yes, my Lord. My Lord, my AG, Attorney General has asked us to please crave the court's indulgence for a further date because of the political situation and they're moving around. He's not been able to sign the terms of settlement.
Yes, Registrar, give us a date after the gubernatorial election.
My Lord, the date in March.
Yeah, any date after the what? Yes, give us if it is possible. If it is possible, and towards the end of March or early April.
My Lord, we don't have any date in April. Our vacation starts from 2nd, finishes
2nd
on
of
the
what?
17th.
2nd of April?
Yes, my Lord, 2nd of April, and it will end in 17th of April, and the
Yes.
Salah holiday will cover the rest of the weeks. So, my Lord, if we give them a date, it will be 27th of March or 2nd of May.
27, March 27.
Of March. Yes, my Lord, this month or
Okay.
2nd May.
They should come back in March.
Yes, my Lord.
My Lord's indulgence for me. So by then we are sure that it could have been signed by then.
This case is adjourned to 27th day of March 2023 for further report of settlement
As the court please.
Or adoption of finality or the adoption of terms of settlement.
As the court pleases.
The court pleases.
Most obliged, my lord.
You are welcome.
Thank you, my lord.
So call the next case.
Suit number NICN CA 51/2019 between Noah Karen and Federal College of Education, Obudu. My lord, the parties are absent.
Parties absent.
Yes, my lord.
Sorry, the claimant is
Appearance.
present.
Please, it's not answering. Please, where is he? He didn't respond.
He muted himself.
Appearance.
May it please this honorable court, Kelvin
Yes.
Otiku. My lord, my humble appearance is for the claimant.
With utmost utility.
Yes.
Oga Eojubo.
Oga A. Ojubo
The defendant.
was the defendant.
Yes, my lord.
Mr. Ojubo, you are appearing with who? Mr.
I'm very
Ojubo,
for the College of Education, the
I
defendant.
say appearing with who? Are
I'm
you
appearing alone,
alone?
my,
Okay. Okay.
I'm appearing alone, my lord.
Okay. This matter is for judgment. The judgment is ready. This is the judgment of the court. On the 18th of December 2019, the claimant took out a general form of complaint against the defendant. By the paragraph 38 of the statement of facts, the claimant claim against the defendant is as follows. A declaration that the defendant did not afford the claimant fair hearing before terminating claimant's appointment. B, a declaration that the revised condition of service for colleges of education that the defendant did not comply with the Public Service Rules 2009 and the revised conditions of nation. D, an order directing the defendant to pay the claimant's promotion arrears from October 2015 at the rate of 28,000 per month till date. E, an order directing the defendant to pay the claimant's promotion arrears at the rate of 16,000 per month from October 2012 to October 2013. F, cost of filing this suit assessed at 1 million naira. Upon being served with the originating process commencing this suit, the defendant enter appearance and filed defense on the 8th of August 2020, and the memorandum of appearance and the statement of defense were deemed properly filed and served. The claimant, Noah Krian, testified in proof of his case as CW1. CW1 tendered documents in evidence. They were admitted and marked as Exhibit A to T. One, Boniface Ochelebe Iyambe testified as DW1 in the defense of the defendant. DW1, at the end of his testimony, was cross-examined by the counsel for the claimant, and thereafter he was discharged. the case of the claimant, I have summarized the case of the claimant, so I will skip reading that aspect. Then the case of the dependent also, I will skip reading it. The submissions of the dependent, Mr. Ojubo, Esquire Counsel for the dependent, who franked the final address of the dependent, formulated 3 issues for determination. They are: 1, whether the dependent afforded the claimant fair hearing before termination of his employment; 2, whether the dependent complied with the revised condition of service for colleges of irrigation 2015. Counsel, sorry, the internet, you know, this technology. I hope you are hearing me.
Yes, my lord.
Yes, my lord.
Yes, my lord.
My lord, we are no longer hearing you, my lord.
It appears I'm having challenges with the internet, with the system I'm using, so I'm going to change the device.
As the court pleases.
The court pleases.
Just give me one minute. I'm almost there. Yes, I think this one will be better.
Yes, my lord, we are hearing you now.
Okay. Yeah, so I have also captured the submissions of counsel in reply to the claimant's final written address. So I will proceed to deliver my decision. Sorry, Council, I'm trying to scroll to where I started my decision. Yes, I have carefully considered the processes filed in this suit, the evidence led by the parties, and the written and oral submissions of counsel for both sides canvassed in support of the cases advanced by their respective clients. The crux of the claimant's case is that determination of his employment by the defendant did not follow due process of law, and that he is entitled to be reinstated back to his job and payment of his balance on salary due to him due to his promotion to higher grade levels. In determining the appropriateness or otherwise of termination of employment, the nature of the contract of employment plays a crucial role in how the dispute is resolved. As pointed out by the claimant, there are three categories of contract of employment, namely, 1, pure master and servant relationship, B, servant who hold office at the pleasure of the employer, and C, employment with statutory labor. The claimant in this case is of the view that his employment is one that has statutory labor because it is governed by statute. The claimant insisted that his employment is governed by Exhibit A, his letter of employment, the revised conditions of service for colleges of education 2015, and the public service rules 2009, while the defendant is of the view that the claimant's employment is governed by revised conditions of service for colleges of education 2015, and not the public service rules 2009. Happily, there are no doubt of authorities on this thorny issue that keep cropping up once employee is a public officer and the defendant is a statutory body. I shall, however, make it clear that the mere fact that a body is an establishment of a statute does not, without more, make such a body have its employees' employment be clothed with statutory labor. See the case of Pakwade versus OAUTH. See also Idigbe Ubu versus NNPC. It is clear from the above cases, from the decided cases on this issue, such as Olanian versus University of Lagos, Eperaku versus University of Lagos, Olorun Toba Oju versus Abraham Oba, the Council of Federal Polytechnic Movie versus Yusuf, Pediatric Hospital Management Board versus Edosa, UNTHMB versus Inoli, Okomo Oil versus Iserian, Bamboy versus University of Ilorin, Imolome versus WAEC, Iguilo versus CBN, and a host of others too numerous to mention, that the rules and regulations which are capable of giving or donating statutory labor and be of protection to the employee must have statutory enforcement, or at any rate be regarded as mandatory and be directly applicable to the employee or persons of his cadre. Generally, where the provisions of a statute governs the conditions of employment of an employee, the court regards the employee as having secured a special legal status other than the ordinary master and servant relationship, which is employer, other than the ordinary master and servant relationship. In that case, the employer is bound to comply with the conditions when it comes to issue of dismissal or terminations of appointment. Otherwise, the act of termination would be declared will be declared wrongful, null and void, and of no effect. However, where an appointment is not governed by any statutory provision, it does not enjoy statutory protection and cannot be said to have statutory labor. In determining what an employment with statutory labor means, the Apex Court has held times without numbers that it relates to employment in the public or civil service of the Federation, state or local government, or agencies of government, including institutions and parastatal, wherein the civil service or public service rules apply or are made relevant or incorporated. See the case of Kwara State Polytechnic, Ilorin versus Shitu. See also University of Ilorin versus Abe. See also New Nigeria Newspaper Limited versus Atoyobi. See also Osuma versus Edo Broadcasting Service Corporation. See also Olorun Toba Oju versus Abdrahim. In the Supreme Court case of Controller General of Custom and others versus Controller Guso, the Supreme Court has this to say: an employment enjoys statutory labor when the contract of service is governed by statute or where the conditions of service are contained in regulations derived from statutory provisions. In the circumstances, they invest the employee with a legal status higher than the ordinary master and servant relationship. It is clear from the foregoing that the parent statute must itself directly regulate the employment before it could delegate power to a non-legislative body to make conditions of service with statutory labor. It is sufficient if the parent statute merely governs it. I think the important thing stress is that where there are sections of the principal statute which govern employment and also give the power to make regulations to another body, and they are accordingly made, those conditions of service would be regarded as subsidiary legislation comparing the employment with statutory labor, or the regulations that derive their force from statute were incorporated to be part of the conditions of service of the employee. It was also clear that where regulations or conditions of service that were made pursuant to a legislation are incorporated into the employment is one with statutory labor. In any event, the court must confine itself to the terms of contract of service between the parties, which provide for their rights and obligations. This is because the character of an appointment and status of an employee, in respect thereof, is determined by the legal character and the contract of the employee. Hence, where the contract of employment is determinable by agreement of the parties, there is no question of any contract with statutory labor. The fact that the other contracting party is creation of statute does not make any difference. However, where the conditions for appointment or determination of the contract is governed by the preconditions of the enabling statute, so that a valid determination of appointment is predicated on satisfying such statutory provisions, the contract will be one with statutory labor. The contract is not determinable by the parties, but only by statutory preconditions governing its determination. Thus, in the instant case, the mere fact that the defendant is a federal government agency established by statute and that the claimant is a public servant within the context of the provisions of Section 718 of the 1999 Constitution as amended does not without more translate to employee with statutory labor. For an employment to be said to have a statutory labor, the appointment must have been protected by statute. In other words, an employment is with statutory labor when the appointment and termination is governed by statutory provisions. Thus, an employment with statutory labor arises where the contract of employment is governed by the provisions of a statute, or where the conditions or terms are derived from statutory provisions. The employment invests the employee with legal status higher than the ordinary contract of master and servant. See Olanion, University of Lagos. See also Imolome versus Imolome versus Waye. See also Balogun versus University of Abuja. It is apt. It is apt at this juncture to determine the conditions of service applicable to the claimant, as the conditions of service is what will be used to determine the dispute between the claimant and the dependent. Section 6, sub J of the Federal Colleges of Education Act has stated the functions of the Government Council of the dependent to include recruitment of staff and the right caliber and determine the career structure of such staff. By Section 15, subsection 1 of the Federal Colleges of Education Act, also the council may appoint such other employee to be employees of the college as council may determine to assist the provost and the principal officers of the college in the performance of their duties under the act. It is without doubt that the above provisions of the law are very clear and unambiguous in that the governing council of the dependent has the power to recruit and employ members of staff for the dependent. Thus, the employment of the claimant as per Exhibit A was done in furtherance of the powers of recruitment conferred on the governance council of the dependent. This means that his employment was done or was backed by statute. By the provisions of subsection 2 of Section 15 of the Federal Colleges of Education Act, the governing council of the dependent is vested with the power to determine conditions of service of employees of the council of the dependent in consultation with the Federal Civil Service Commission. However, none of the parties in this suit has referred the court to the terms and conditions of service made by the governing council of the dependent in line with the provisions of subsection 2 of Section 15 of the Federal Colleges of Education Act. There were no terms and conditions of service made or enacted by the governing council of the dependent in the exercise of the powers conferred on it by Section 15, subsection 2 of the Federal Colleges of Education Act. In Section 5L of the National Commissions for Colleges of Education, the commission was vested with power to undertake periodic review of terms and conditions of service of personnel in colleges of education and make recommendations thereon through the minister to the federal government. A careful perusal of Exhibit A, the letter of employment of the claimant, in the last paragraph, it states as follows, I quote, "Please note that all other conditions of service remain the same as they apply in the federal civil service system. The college conditions of service and as the governing council will determine from time to time. It is clear from the above quoted provisions in Exhibit A, the letter of claimant's employment, that the public service rules have been incorporated to be part and parcel of the terms and conditions of service governing the employment of the claimant. In Exhibit B, the letter of termination, the claimant's employment was said to have been terminated by the governing council under the Federal Colleges of Education's under the conditions of service for colleges of education, revised conditions of service for colleges of education 2015. The governing council relied on the provisions of that conditions of service, which is Exhibit G before the court, in terminating the claimant's employment. Therefore, reliance on Exhibit J to determine claimant's employment is a pointer to the fact that the Governing Council of the Dependent intended Exhibit J to be one of the documents to govern the employment of the claimant. The combined implications of Exhibits A and B, the provisions of Section 6J, Section 15 of the Federal Colleges of Education Act, and Section 5L of the National Commission for Colleges of Education is that it will be correct to state that the terms and conditions of service applicable to the employment of the claimant in this case are as contained in the Public Service Rules, the Revised Conditions of Service for Colleges of Education Act 2015, and Exhibit J. This conclusion was reached based on the fact that Exhibit A, which kickstarted the employment of the claimant or clearly incorporated the Public Service Rules, and Exhibit J, the Revised Conditions of Service for Colleges of Education. This was relied on by the defendant to terminate the claimant's employment as per Exhibit B. This means the claimant's employment is one that is invested with statutory labor because the Public Service Rules and the Revised Conditions of Service for Colleges of Education 2015 govern the said employment. And these documents or the conditions of service were made pursuant to the Constitution and the statute respectively. The law is well settled that except in employment governed by statute, wherein the procedure for employment and discipline, including dismissal of employee, are clearly spelled out. Any other employment outside the statute is governed by the terms under which the parties agreed to be master and servant. Employment with statutory backing must be terminated in a way and manner prescribed by the relevant statute, and any other manner of termination inconsistent therewith is null and void and of no effect. But in other cases governed only by agreement of the parties and not by statute, removal by way of termination or appointment or dismissal will be in the form agreed. Any other form connotes only wrongful termination or dismissal, but not to declare such dismissal or null and void. The only remedy is claim for damages for that wrongful dismissal or termination. This is based on the notion that no servant can be imposed by the court on unwilling master, even where the master's behavior is wrong. For his wrong act, he is only liable to damages and nothing more. See Olanian University of Lagos, Sufra, Akinte versus Owume Chili, see Epereku versus University of Lagos, see Ayetan versus Insupo, see Sapara versus UCH Management Board, see also Union Beverages Limited versus Olabi. It is well settled that if any disciplinary action is to be taken pursuant to any statute law or rule, there must be full compliance with them or any of them as required before such disciplinary action can be properly based or justified. See the case of United Bank UBA versus Ogbo. See UBA versus Ogbo. From the foregoing, it is clear to me that Exhibit A has incorporated public service rules and Exhibit B has made the revised conditions of service of colleges of education relevant to the claimant's employment. This renders this means for any disciplinary action to be valid, it must be carried out in line with the laid down rules and regulations as contained in the public service rules and revised conditions of service for colleges of education. The absence of rules and regulation made by the council to the dependent has also made the public service relevant, applicable to the claimant's case, to the claimants being a public servant whose employer as agency or organization or institution or parastatal of government does not have rules and regulation in place. See the case of Olowoni versus EFCC, where the Court of Appeal for Ergata JCA has this to say: the public service rules require that parastatalists to have their handbooks properly made. They are required to resort to public service or civil service rules of the Federation. 2008 Rule 160103 provides that parastatals are to retain and improve existing rules, procedure, and practice in their establishments to ensure that there are no deviations from the general principles contained in the public service rules. For example, variation in probationary period and maturity period for promotion only reflects organizational peculiarities and not inconsistencies with the public service rules. However, in the absence of internal rules and regulation on any matter, the relevant provisions of the public service rules shall apply. Having established the status of employment of the claimant and the terms and conditions of service governing his employment, I shall now proceed to examine whether the claimant's employment was properly terminated or not by the defendant. The claimant was employed by the defendant as per Exhibit A. The employment of the claimant was confirmed as per Exhibit B. The claimant had his employment converted from messenger to curator and subsequently promoted to become assistant chief coach. See Exhibit C, D, E, F, G, and H. By the Exhibit AA and S, claimant was queried for absenteeism. He answered the query as per Exhibit T, wherein he claimed that his absence was because he fell sick while on leave, and that his head of unit had by the letter dated 14th day of March 2017 notified the defendant of his illness as per Exhibit O, and the claimant himself had notified the defendant of his sickness as per Exhibit P1 to 2. The defendant insisted that the claimant had his employment duly terminated in accordance with the revised conditions of service for colleges of education, Exhibit J. The claimant was issued with query as the claimant was issued with query, and he responded, and he appeared before the Management Disciplinary Committee and the Council Ad Hoc Committee. According to the defendant, the claimant was given opportunity to defend himself, and the rules and regulations governing his employment were duly followed. The grounds of the claimant is that though he was queried, answered the query, and appeared before the ad hoc committee of the governing council, which he considers to be an investigative committee, it made a recommendation for the termination of his appointment, and the governing council, without giving him fair hearing or inviting him to appear before the governing council, terminated his appointment. From the pleadings and evidence of the parties, the area of dispute between the claimant and the defendant lies in whether the claimant was accorded fair hearing before termination of his employment following allegation of misconduct bordering on absenteeism from work, and whether disciplinary action proceedings can last for a period exceeding 60 days. Let me say here that the court is not concerned with whether the claimant is guilty of absenteeism from work as alleged. All that the court is concerned with is the procedure adopted in terminating claimant's employment. Was it proper and in tandem with the rules and regulations governing termination of the claimant's employment? The reason being that this court is not hearing appeal against the decision of the governing council of the defendant. In determining employment cases, the court is not meant to be another forum for the trial of the claimant. When a matter of termination or appointment is brought before the court is, in essence, is not sitting as a court of appeal over the decision of the employer. It is, in a sense, reviewing body. The system of judicial review is not the same as that of appeals. When hearing an appeal, the court is concerned with the merits of the decision under appeal. When dealing, however, with administrative act under such as the dismissal or termination of an employee or the exercise by the government official of his powers to the detriment of a citizen, a court is concerned with its legality. That is, whether the employer or government official followed the right procedure as laid down by the conditions of service in respect of the act under which the government officer acted, including the observations. Generally, if the rules of natural justice are not followed in circumstances where they should be, then the remedy given by the court will be to nullify the decision or declare that it is invalid. But this remedy may be withheld by the court even where they are satisfied that the rules of natural justice have not been complied with. If the court thinks that the person complaining does not deserve to win. See the case of Gleeman versus Keeley University. It is right law that in taking disciplinary action against an employee whose contract of employment is governed by statutory provisions, the laid down procedure or contained in the statute or rules and regulation governing employment must be followed to the latter. Any deviation will render the termination null and void. See the cases of Olanion and others cited above. It is also the law that where an employee is sought to be removed in contract with statutory labor, that is a contract of employment wherein the procedure for employment and discipline, including dismissal, are spelled out. Such a contract must be terminated in the way and manner prescribed by the statute. Any other manner of termination which is inconsistent with the relevant provisions will be null and void and of no effect. Rule 160103 of the Public Service Rule provides parastatal to retain and improve existing rules, procedures, and practice in their establishment and ensure that there are no deviations from the general principle contained in the public service rules. For example, the variation in probationary period and maturity period for promotion only reflects organizational peculiarity and not inconsistencies with the public service rules. However, in the absence of internal rules and regulation on any matter, the relevant provisions of the public service rules shall apply. Also, in Rule 160501 of Section 5 of Chapter 16 of the Public Service Rules 2009 provide the power to exercise disciplinary control over officers in parastatal is vested in the supervisory boards to councils in accordance with the respective conditions of service. It is clear as daylight that disciplinary control over officers in other government agencies other than those agencies in the case at hand. It is the governing council of the defendant that is vested with power to discipline the employees of the defendant, including the claimant. The claimant in this suit, being an employee of the defendant, is under the control of the governing council of the defendant on issues of discipline like the case at hand. See also clause 5.0.2 of chapter 5 of XBJ, the revised conditions of service for colleges of education. However, where there is no governing council in place, the power is vested in the expanded management committee subject to the approval of the minister. See also clause 5.0.3 and 5.0.4. The provisions of Rule 160502 of the Public Service Rules provide the provisions of Section 2 and 6 of Section 2 to 6 of Chapter 3 of the Public Service Rules shall guide all parastatal in addressing disciplinary matters, provided that where reference to the Federal Civil Service Commission, head of civil service of the Federation, or the permanent secretaries, or the board or council shall perform such practice. The board and council shall perform such functions. The claimant in this case was accused of absenteeism, which is classified as serious misconduct. See Public Service Rule 030402, clause 5.1.3.1.5 of Exhibit J, the revised conditions of service for colleges of education. By the provisions of the rules of Rule 030413 of the Public Service Rules, any officer who absented himself from duty or traveled out from Nigeria without leave rendered himself or herself liable to be dismissed from service, and the onus shall be on him or her to show that the circumstances do not justify the imposition of the full penalty. The disciplinary procedure is as contained in clause 5.254 to 5.44 of Exhibit J. The disciplinary action to be taken after following the disciplinary procedure is as stated in clause 5.5 of Exhibit J, and termination is listed as item 8. By the provisions of Public Service Rules 020305, if representation is made to the Federal Civil Service Commission, in this case the governing council of the defendant, that an officer has been guilty of misconduct and the commission does not consider the allegation serious enough to warrant institution of proceeding for dismissal, the commission governing council may cause an investigation to be made into the manner in which such a matter as considers proper, and the officer shall be entitled to know the whole case made against him or her, and shall have adequate opportunity on making his or her defense. In any event, the rule allows the governing council through allegation, though the allegation is proved, to decide to inflict any other punishment upon the officer, such as reduction in rank, withholding of increment, or otherwise. In the case at hand, the governing council has set up an ad hoc committee to determine to investigate the claimant, and the committee, after its report submitted to the council, recommending termination of the claimant's employment, and the council accepted and terminated the claimant's employment. In the case at hand, the council defendant, upon receipt of the representation respecting the claimant's absenteeism, set up an ad hoc committee where the claimant appeared in defense of the allegation of misconduct. By the provisions of Rule 030305 of the Public Service Rules, the Governing Council has power to establish committee to look into allegation level against claimant. Therefore, the ad hoc committee was set up was in order and in conformity with the law. It is to be noted that the acts of misconduct with which the claimant was accused of committing, i.e. absenteeism, is by the rules and regulation punishable with dismissal from service. However, the defendant However, the Governing Council, on its own wisdom, chooses to terminate the appointment of the claimant, which translates to impositions of lesser punishment. An employer has unfettered discretion to give a lesser punishment on an employee, but he has no discretion to give a higher punishment than that prescribed in the instant case. Although the Public Service Rules and Exhibit J, revised conditions of service for colleges of education, have prescribed penalty of dismissal for absence from duty, the governing councils has unfettered discretion to decide to give a lesser punishment of termination. It is my view that the defendants and this is in compliance this position finds support with the Supreme Court decision in Oduk Bunam versus FCDA, where the punishment for dismissal was Uduapan case, in which punishment of termination of employment was imposed instead of dismissal, and the Supreme Court upheld the decision of the employer. As pointed out earlier, the grounds of the claimant is that the defendant in terminating his appointment did not follow due process, as he was not invited by the governing council to appear before ordering termination of his employment. However, the defendant insisted that the due process was followed, as the claimant made representation in Exhibit T and was considered by was appeared before the ad hoc committee, and he was given opportunity to defend himself. It is pertinent to reiterate that in an action where the termination of contract of employment with statutory labor or employment protected by statute or rules, a regulation made pursuant to statute for the determination or termination of to be sacrosanct, the employer must strictly comply with the laid down procedure for termination of employment. Otherwise, the entire exercise will amount to illegality or a nullity. See Olanian and host of other cases cited therein. In Eguamase versus a magazine where 1993 9 Nigerian Criminal Report, part 315, the Supreme Court has this to say: I will touch even briefly on the issue of principles in respect of the laid down procedure in a statute or rule of court, which was also briefly discussed in Chief Okereke versus Adwa and others, and as per Onogen JSC as his then was. It is now firmly established where a statute lays down a procedure for doing a thing, there should be no other method of doing it. The case of CCB PLC versus Attorney General of the Federation, Anambra State, and Buhari versus Yusuf, and Adesola versus Alhaji Abidoye all supported this position. They all stated that where a special statutory prohibition is laid down, that procedure ought to be followed and complied with, unless it is such that it may be waived. Applying the above principle of law as enunciated by the Apex Court, it will be correct to state that the defendant in this case is duly bound to comply with the provisions of the and public service rules in exercising its power of disciplinary action against the claimant. In Chapter 5 of Exhibit J, comprehensive rules have been laid down, rules and procedure to be followed in taking disciplinary action as an employee of the defendant. However, a careful perusal of Chapter 5 will reveal that there is no established standing committee established under Exhibit J to deal with disciplinary case involving employee of the category of the claimant in circumstances and in line with Rule 16103, which provides that in absence of internal rules and regulation on any matter, provisions of public service rules shall apply, was utilized. Since there is no extant provisions regarding setting up committee to try claimants under Exhibit J, recourse will be had to Chapter 3 of the Public Service Rules. I have thoroughly examined the entire provisions of Chapter 4 of the rules. It is clear to me that setting up of ad hoc committee is justified under Rule 030305 of the Public Service Rules. Therefore, the claimant was given fair hearing in the proceedings of the ad hoc committee. In the case at hand, the claimant was queried as per Exhibit AA. He answered the query Exhibit T. Thereafter, an ad hoc committee was set up to try the claimant for absenteeism, which is a serious misconduct deserving punishment of dismissal from service. This ad hoc committee, after hearing from the claimant, submitted his report to the Governing Council, which upheld the recommendation to terminate the claimant's employment. Exhibit B was issued terminating claimant's employment. The claimant was, to my mind, given adequate opportunity to defend the allegation level against him as per Exhibit AA, and the claimant did defend himself in both response to the query and appearance before the ad hoc committee of the Governing Council, which is equivalent to Federal Civil Service Commission in case of disciplinary action. The decision taken in terminating claimant's appointment was a lenient one, considering gravity of the offense of absenteeism. The claimant seems to rely on cases of Bamboy versus University of Ilorin, Olanian University of Lagos, Olutega versus University of Ilorin, in contending that for the termination of his employment to be valid, he must be invited to appear before the council. I must state here that these cases were cases that were determined based on Section 17 of the University of Lagos and Section 15 of the University of Ilorin Act. These sections of the statute are not same with the provisions of the Public Service Rules. And in the case at hand, the claimant, though his employment is close with statutory labor, the provisions governing his employment is not same with the provision governing employment of university lecturers. The claimant, university lecturers whose case were considered in the cases relied. The claimant has also relied on the case of EMC versus Federal Inland Revenue Service. In that case, there was no any committee set up. It was only the responses, that is to say, the reply to the answers to the query given to the employer that were considered, and the claimant and termination was effected. That's why the Court of Appeal found that no fair hearing has been given to the claimant. The case of BMC is not on all fours with the case at hand, having found that the ad hoc committee was proper and the claimant was afforded opportunity to defend himself. The claimant is not entitled to declaration that he was not afforded fair hearing before his appointment was terminated as per Exhibit B. I now turn to the issue of compliance with the rules and regulations in terminating claimant's employment by the defendant. The claimant insisted that the rules has made it obligatory for any disciplinary proceeding against employee to be concluded within 60 days. However, in the case at hand, disciplinary action spanned for a period of more than 1 year. I have scrutinized the provisions of Rule 03037 of the Public Service Rules, which reads, I quote, all disciplinary procedure must commence and be completed within a period of 60 days, except where it involves criminal case. It is tried to know that the primary concern of the court when considering a piece of legislation is the attainment or ascertainment of the intention of the legislature by the examination of the language used therein, where the language used by legislature or statute as constitution is clear, explicit, and unambiguous. The court must, without any equivocation, give effect to it as the words used speaks for themselves. See the case of Amesi versus INEC. Therefore, when a court is faced with interpretation of statute which is unambiguous and clear, such as Rules 030307 of the Public Service Rules. It is to be given the provision must be given literal interpretation. See the case of Pawumi versus IGP. See African Newspaper versus Federal Republic of Nigeria. See Nigerian Army versus Abuo. Clear and unambiguous provisions of statute must be given their ordinary grammatical meaning. See the Matic Nigeria Limited versus Utuk, applying the above rules of interpretation enunciated in the above provisions of the public, in the above decisions of the Supreme Court to the rules, to the public service rules under consideration. I have no choice than to come to the conclusion that in any given case of discipline under the public service rules, adherence to 60 days is mandatory insofar as there is no involvement in criminal case. Exhibit AA is what ignited the disciplinary action against the claimant, as it is what started the processes of discipline against the claimant. And Exhibit B, letter of termination, is what concluded the disciplinary action. From 1st of August 2018, when Exhibit A was issued, to 23rd day of September 2019, when the claimant's employment was terminated as per Exhibit B, there is a period of more than 1 year. This means the dependent did not comply with the 60 days provided by the rules within which the disciplinary action against the claimant must be completed and closed. This is also a clear pointer to the fact that the dependent did not comply with the rules in terminating the claimant's employment. In the circumstances, the termination of claimant done in disregard of Rule 030307 has rendered the termination of the claimant null and void and of no effect. It must be remembered that the claimant's employment is one with statutory playbook, and disciplinary action has to be taken within the confines of the law, and the dependent having violated the law has jeopardized the processes culminating in termination of claimant's appointment. The infraction committed by the dependent has rendered termination of appointment of the claimant as per Exhibit B to be liable to be set aside. In reliefs D and E, the claimant is seeking for an order of court directing the dependent to pay the claimant promotion arrears from October 2015 to at the rate of 28,000 per month to date. He is also praying for order directing the dependent to pay him arrears of promotions at the rate of 16,000 naira per month from October 2012 to October 2013. The law is settled that in a claim for wrongful termination of employment, the employee can also claim for salaries and other entitlements earned by the employee, but not paid by the employer at the time of termination. See Odubonam versus FCDA Tufra. In proof of claim for arrears of promotion, the claimant relied on Exhibit G, H, and X1 and P1 to 2, which are letters of promotion, salary pay slips for June and August. The law regarding payment of salary arrears is that it is a claim for special damages, which must be specifically pleaded and strictly proved. See Attorney General of Oyo versus Fair Lakes Hotels. See also 7-Up Bottling Company Limited versus Kilipo. Exhibit G and H Being letters of promotion can only prove that claimant had been promoted to certain grade level of salary scale. The only slip tendered can only be proof of salary which the claimant had been receiving based on his grade level before the promotion, but there is no any other evidence to show salary which claimant is entitled to be paid as per his promotion. The reason being that before salary is paid, the employee, there are certain deductions to be made from his salaries. In the case at hand, that had not been established to enable the court knows the exact amount claimant is entitled to as arrears of his salaries after promotion. From the foregoing analysis, the claimant has succeeded in part of his claim. For avoidance of doubt, the order of the court is as follows. 1. The termination of claimant's appointment having been done outside the period of 60 days permitted by the rules for conduct of disciplinary action is hereby declared null and void. The said termination as per Exhibit B is hereby set aside. 2. The defendant is hereby ordered to reinstate the claimant back to his job with immediate effect with all his entitlements. 3. The claim for arrears of salary due to promotion fails as the claimant has failed to strictly prove entitlement to that. So he is entitled to it, but he has not proved the exact quantum he is entitled to. The claimant is entitled to cost assessed at the sum of 500,000 naira. The defendant is to pay the claimant the sum of 5,000 naira, 500,000 naira as cost. Judgment is entered accordingly.
As the court pleases.
All of you are very grateful for such a wonderful judgment. We appreciate. We pray that God will give you more wisdom to do more. Thank you, my Lord.
It's all right. You are welcome.
Let's go.
Won't you thank my Lord?
Okay. You are welcome, Mr. Ojubo.
Thank you, my Lord.
Mr. Ojubo.
My Lord.
Yes, you are client. You are client, the College of Education. Are you hearing me?
I'm hearing you, my Lord.
Yes, I say you are client, the Federal College of Education. They are not doing what they are supposed to do. The rules and regulation concerning discipline is very clear. So they should be able, their human resources department should be able to study them very well to know how to be handling their disciplinary action. How can you query somebody and you could not complete the process until after for it take you more than a period of 1 year? I don't think if you have a good case against your employee, it should take you more than 2 weeks to conclude it. It is not good. You know, they say delay defeats equity. Yes, registrar, any other case?
No, my Lord, that's all, my Lord.
Okay, thank you very much, Counsel, for joining us.
Thank you, my
We have
Lord.
come to the end of
Thank you,
today's
my Lord.
proceeding, virtual proceeding. The
Thank
administrator
you, my
will
Lord.
continue with the proceeding. Thank you very much.
Thank you, my Lord.
Thank you.